All right, good morning. Up next, we've got Starrett v. Benson, file 24-9023CZ. Counsel, you want to state your appearances beginning with the plaintiff?
Good morning, Your Honor. Kevin Cleaborn. I represent the plaintiffs.
Your Honor, Kurt Thornblade, P25858. I represent the defendant.
Okay, good morning. We've got three motions up today. Defense motion for relief from judgment, plaintiff's motion to enforce the judgment, and defendant's motion for bond pending appeal. I guess maybe we should first take the plaintiff's motion to enforce the judgment, because it sounded like from some of the later pleadings that came in that some of the issues raised in Mr. Cleaborn's motion may have been ameliorated. So let's take that motion first. Mr. Cleaborn, go ahead.
Can I remain seated, Your Honor?
Yes, that's fine.
Your Honor, we filed the motion as we've had possession since mid-September. And so once we had to go to the trouble of evicting the defendant, we expended costs for the sheriff's service fee. That was in the amount of $82, $200 to get the defendant's belongings removed. And then we rented a storage unit for a month, and we've expended $40 on that. I was hoping the defendant even might be here so I can pass off the storage unit key to the unit so he can remove his stuff. The only other issues that I can see is that he's moved his jet boat and a couple of jet skis a little, and there were 3 vehicles there. They appear to be still on the plaintiff's property, and so we were asking for in order to just get those off. He's got the 2 vacant lots next door. It would not be too difficult to move those items to his own property. So anyway, we don't know where the defendant is now living, but obviously he's been living elsewhere for a couple months now. So we're hoping to get repaid for our $322 that we've expended, and get all of his property off our property.
Okay, Mr. Thornblad, your response to that motion?
Yes, Your Honor. Our response was to ask to have this held in abeyance, simply because if Mr. Cleaborn would share with me what it is that he wants, I probably could stipulate to it, subject only to not waiving our appeal rights on it. So
well,
if I were given the information, I might agree to it. Good chance.
All right. Well, Mr. Thornblad was given the information by way of the motion, which stated very specifically what the plaintiff wants. There's been no reason not to do that. Plaintiff's motion to enforce the judgment is granted. I would sign an order, Mr. Cleaborn, ordering the defendant to pay $322 in costs, and order the defendant to remove any property still remaining on the premises and not within 21 days. And you can submit.
Your Honor, that's the extent of the relief Mr. Cleaborn wants. I could stipulate to that, subject only to I don't want to waive the appeal rights on it.
Oh, sure. Okay. All right. So I'll enter that as an order, not as a stipulated order then, so that there's, appeal remedies is fine.
That'd be fine.
Where should I send the key?
Yeah. So Mr. Thornblad, Mr. Cleaborn has some personal property that they have removed from the premises and placed in a storage unit. Where should he send the key? Should he send it to your? Okay, send it to Mr. Thorn.
Okay. 7301 Schaefer, Dearborn, Michigan, 48126-4915.
Okay, very good. All right, you can submit an order to that effect, Mr. Cleaborn. And now we have defendant's motion for relief from judgment and motion for bond pending appeal. Maybe we could hear argument on both of those motions at the same time. Go ahead, Mr. Thornblad.
Thank you, Your Honor. This motion rests on 2162 C1, C, and F. I do acknowledge that in the original motion, the title page had subsection B in it, but we are not relying on it. We're relying on C and F. C would be a fraud or misstatement on the court. The affidavit of Dr. Starrett and his sister both indicate they were not aware of the the deed for a long period of time. That's the affidavit. The court put the onus on us to show that the 15 years had passed. However, there was a mortgage that was referenced by a defendant in his deposition. The mortgage was entered within months of the deed being recorded. That it puts the plaintiff's awareness of when it was recorded past the way earlier than the 15-year period at the time of the filing of the case. And also it establishes the estoppel. I would just say in this case, this is a family dispute. That's the most vicious, backbiting form of a litigation. There are no good guys. There are no bad guys. Everything has to be corroborated. The doctor's statement is not corroborated.
All right, thank you. And as to your motion for bond pending appeal, anything you want to say about that?
Yeah, brother counsel pointed out I had a reference to a statute which is in a positive. I filed a response, and I withdraw any claim of support on that. I do state that I've been a lawyer 50 years. I've filed a lot of appeals. I have never had a judge grant me a stay pending appeal. The judge has to, first of all, admit that there's a probability that he'll be reversed. I've never had a judge do that, but the Court of Appeals asks us to go to the trial court first in their wisdom, and I'm doing that. So I just ask Your Honor, if you find it in your heart after reviewing the file that it should be stayed, maybe we could just arrange for my client to be able to stay in the property and pay some reasonable rent, like $750 a month.
Mr. Thornblad, I have to tell you, that is my favorite argument I have heard in the last 5 years. All right, Mr. Cleaborn, your response.
I am chuckling as well, Your Honor. Your Honor, I feel like I'm re-arguing the summary disposition motion again, but the court granted our motion on the deed delivery issue. It dismissed his claim for adverse possession because he admitted it was communal and that he had not been there. And so that's the reason the court dismissed the defendant's counterclaim for adverse possession. But again, from his deposition, the court properly granted our delivery of deed issue, because when I asked him where the deed was, quote, this is page 24 of his deposition, "I have no idea where the deed was. It might have been in my grandmother's possession. It might have been in my mother's possession. I didn't have it. I didn't even know it existed." Question number 2 then. "And you have no idea where your mom kept it or where the deed was?" Answer, "I have no inkling." And so, I mean, that's the reason why the court properly granted our relief on the delivery of the deed issue. And so, again, I'm just a little puzzled at this whole motion, quite frankly. I guess with regard to the bond issue, the status quo is he's been ordered out, and he's been out since mid-September. And so the place has already been secured. It's been winterized, pipes blown out, that kind of thing. Obviously, he's been living somewhere else for 2 months.
I do have one question for you about the bond pending appeal, and I would not be inclined to allow defendant to resume possession of the premises. So I'm not going to stay the possession or the legal effect of the order. However, he has pursued his appellate remedies, and your client, as it sits today, could simply sell the premises. And then if the defendant prevailed on appeal, he'd be left essentially without a remedy. So should I at least grant the motion in part to allow him to file a Liz Pendens or something?
I guess so. It's a family compound. And so I think that order would be academic, if you will. I mean, the Sterretts have cabins next to each other. The purpose for all of those parcels up on Carp Lake is to have a place for family gatherings.
So you're stating that there's no present intention of your parties to alienate the premises?
No, none whatsoever.
All right, thank you. Mr. Thornblad, any rebuttal argument, sir?
No, thank you, Your Honor. That would be a sensible resolution of this matter. If we could just file a lease pendants, I think that substantial justice would be done.
All right, thank you. Well, as to the defendant's motion for relief from judgment, I'm going to deny that motion. It's based upon some information from a mortgage that shows that in the spring of 2003, the plaintiffs had secured the defendant's signature on a mortgage, showing that they had some knowledge of his asserted interest at that time. However, the basis for the summary disposition was the failure to deliver the deed prior to the grantor's death. The 2003 mortgage does nothing to change the fact that there was no delivery or recording of the 2000 deed until after the grantor's 2002 death, and that the plaintiff didn't know about the deed until sometime after the grantor's death. So there's no showing of fraud or other reason to grant relief from judgment. That motion to be denied. The motion for bond pending appeal will be denied in part and granted in part. And the relief that I would grant is I would not stay the order pending appeal or grant defendant possession of the premises, but I would allow defendant to file a Liz Pendens with the clerk's office indicating the ongoing appellate litigation. And Mr. Cleavorn, I guess since you have prevailed on the motion for relief from judgment and substantially prevailed on the motion for bond, could you submit an order
I can do
on those
that.
as well?
Sure.
Okay. And you can
Your
combine them all.
Honor, yeah, I'm willing to do it. I don't see why we should lose time going through the 7-day motion. I'd be willing to stipulate if Mr. Cleveland wants to send it to me.
Okay, great. Okay, great. So you can just prepare a stipulation as to form and combine all three motions in one order is fine with
Okay.
me. All right, anything
you,
else,
John.
Mr. Thornblad?
No, Your Honor, thank you. I would urge 53rd Circuit to adopt my file. The clerks like it. They adopted it in 25th and 19th just recently, and I was down there talking to the clerks, and the ladies in the clerk's office were very happy to have my file. So I asked you to consider that.
Yeah, you know, we're actually in progress with that. We need our probate courts to switch a technical issue on the case management system that's scheduled for January. And we are on the schedule to go to my file sometime next spring or summer.
Thank you, Your
So,
Honor.
yes, indeed. We are looking forward to it. All right, you have a good day.
Thank you.
Back on the record in the 53rd Circuit Court for the County of Sheboygan. And again, we are providing public access both in the courtroom and also online. And up next, we have American Express National Bank v. Coughlin, file 25-9115CZ. Counsel, you want to state your appearances, beginning with plaintiff?
Good morning, Your Honor. Michael Bengstein, P69778, on behalf of American Express National Bank.
Good morning.
Good morning, Your Honor. Leslie Honig, P71763, on behalf of the defendant, Charlene Coughlin.
All right, good morning. This is a motion for summary disposition filed by the plaintiff under C9 and C10. I reviewed the motion and the response. Mr. Bengstein, anything you want to say in support of your motion?
Nothing other than, defendant opened the account, made purchases and payments, and stopped paying on the account. Defendant has not demonstrated that there's any material issue of fact and dispute, and plaintiff is entitled to judgment.
Thank you, Ms. Honig.
Your Honor, I don't have much to add either, other than that there is an arbitration clause in the agreement with the original creditor, and I would request a stay for the purpose of starting an arbitration claim.
Okay, that was not in the original affirmative defenses, is that right?
That's a good question. I'm double checking that.
I thought I checked that.
I cannot remember, so I'm just pulling up my answer.
Yeah,
here.
I'm looking at it again, just double checking each of them. It doesn't look like it was. Okay. All right, Mr. Bengstein, your response?
Yes, as the court just pointed out, it was not part of the affirmative defenses. That defense has to be asserted in the first response to pleading, and that was not done. It doesn't appear that defendant is seeking to amend the answer to include that, and it's pretty late in the day to do that. Also, It has to be by motion. There is no motion to compel arbitration. And we have a motion for summary disposition up right now. There's really no, even if there was a motion to compel arbitration, there's really no dispute to be arbitrated. Again, we're entitled to judgment as a matter of law. I don't know what the arbitrators would do other than rack up more expenses for defendant and plaintiff.
All right, thank you. Plaintiff has asserted a breach of contract and account stated for an unpaid credit card debt. Defendant's answer asserted lack of knowledge as sort of a blanket defense. Plaintiff says they didn't truly engage with the claims, so summary disposition under C9 is appropriate. However, the answer did deny a lot of the claims. I think it's a bit of a stretch to say that it failed to state a defense. So I would deny the motion for summary disposition under C9. However, I would grant the motion for summary disposition pursuant to MCR 2.116 C10. There being a showing by the plaintiff that there's no genuine issue of material fact and that they are entitled to judgment as a matter of law. The documentary evidence attached to the defendant's motion, to the plaintiff's motion, establishes the contract and the debt for both breach of contract and the account stated. Defendant has failed to counter with any documentary evidence that judgment should not enter, and defendant's assertion of an arbitration right is too late. It wasn't raised as an affirmative defense in the first responsive pleading. Therefore, I would grant judgment against defendants in the amount of $25,453.60, reflecting the debt plus $245.70 in costs. And Mr. Bankstein, I see that there's a proposed order presented today. However, it did include a grant as to C9. So if you can submit an alternative order, either stipulated as to form or under the 7-day rule, denying as to C9 and granting as to C10.
My understanding, based on what you said, Your Honor, is that if we strike out the C9 language, that we can resubmit that proposed order to the court.
Yeah, actually, I could just add. It says it's hereby ordered that plaintiff's motion for summary disposition is granted, and I could put as to C10 only.
That's if the court wanted to do that sua sponte, that's fine.
Any objection to that, Ms. Hoenig, as to form?
No, Your Honor.
Okay.
And that's not, is this a my file court? Did you want me to resubmit that to you, or are you signing?
We are not a my file court, and we hope to be by the end of next year. But I've got a proposed written judgment in front of me, and I'm going to add that and initial that and sign it.
Thank
So
you, Your
we'll get
Honor.
copies out to folks.
Thank you. Have a happy holiday.
All right. Thank you. You too.